Well, good evening to everyone. We are so very excited to have everyone joining us for the sixth of our web series events. And this one is our litigation roundup for the ACLU of Ohio. My name is Raphael Davis Williams, and I am the Director of Equity and Inclusion at the ACLU of Ohio. And as you just saw a moment ago, joining me is our spectacular legal team led by our fearless leader, Freda Levinson, and also with David Carey and Elizabeth Bonham. So we are so excited to have everyone here joining us, and we really want to give the legal team and all of you the opportunity to really delve into some of the cases that we're going to go into. So we don't want to belabor the moment right now, but I would encourage everyone, if you want to, drop your name and where you're dialing in from in the chat so we can see. We'll have a chance to say hello to you. The way this is going to work, our legal team is going to bring several cases that we are working on that are currently in our litigation docket. We are going to ask that everyone hold questions until the end, or drop them in the chat or in the Q&A box. And that way we can kind of come back around to them after everyone has a chance to give their presentation. So I'm going to, at this point, turn it over to the litigation wizard that she is, and that is Freda Levinson. Freda, take it away.
Thank you, Raphael. We're thrilled to be here this evening to share some of our current docket with you. Before I begin, I'd like to give a shout out to a wonderful cooperating attorney who I think is in the audience, Megan Keenan from the law firm of Covington and Burling, who worked on election protection with us. Thank you, Megan. Also, if there are others of you out there, please introduce yourselves in the chat. I'd like to stress that with ongoing litigation, some information is obviously confidential or strategic. So please forgive us if we don't share as much as you would like us to this evening, things such as future plans or strategy. We'll do as much as we can. We would love to share with you. I'm going to start us off with an overview of our reproductive rights cases. By way of background, Roe versus Wade is still the law of our land, but the forces that want to reverse it have been emboldened, especially with the changes on the Supreme Court. They're waiting for their chance to reverse in the High Court. But meanwhile, they've worked for years already to diminish reproductive rights incrementally, with scores and scores of repressive bills, especially in some states like Ohio, where we're always fighting waves of abortion restrictions. Just about every variety of abortion restriction that you can imagine, and some maybe that you cannot, have been passed here in Ohio. A significant portion of our docket consists of lawsuits defending reproductive rights, and I'd like to discuss 5 of them. First of all, fetal tissue disposal. Late last year, Ohio passed a law to radically change how abortion clinics must manage tissue from surgical abortions. It requires all tissue to be cremated or interred, even when embryonic remains are as small as a zygote or blastocyte. This bill was to come into effect April 6th, a month ago. As the date approached, there were a lot of unanswered questions about how it would be implemented. And the bill imposed very stiff penalties for violations. But the Ohio Department of Health had refused to issue rules for how to comply, or even the forms that clinics were required to use. Of course, the clinics couldn't risk violating the law. So the situation seemed to be an intentional trap, a trap set up for some kind of cynical form of gotcha. Without these rules or forms, the clinics would actually have to stop performing surgical abortions on April 6th. So we sued in state court in Hamilton County, challenging the law and asking for guidance. This case is Planned Parenthood, Southwest Ohio versus McLeod. As soon as we filed, there were several evasive gambits by the Department of Health, which I won't take your time to detail here, except I do want to note that a federal court ultimately ordered the state to pay our legal fees that were incurred by fighting their improper maneuvers. Finally, though, on the eve of the effective date, just the day before, a state court judge was able to hear the case. She ordered right from the bench that very day that enforcement of the fetal tissue law must be delayed until 30 days after the Department of Health goes through a rulemaking process, which itself will take about 2 months. So the DOH was ordered to come up with rules, or you can't enforce the law, and to also to provide time to comply with the law. So for now, the bill is suspended at least until July. The time for the state to appeal this ruling ran out just yesterday. So now, what's left of this case? There remains a possible issue of the constitutionality of the bill itself, these fetal tissue disposal regulations, which we will be able to evaluate after we see how the Department of Health interprets the law when it finally does issue rules. The next case I'd like to discuss is preterm Cleveland versus Himes. The Down syndrome abortion bill, which was passed at the end of 2017, prohibits abortions when part of the patient's reason is a fetal diagnosis of Down syndrome. But a state can't ban abortion prior to viability of a fetus. So we sued and stopped the law before it ever came into effect. The trial court and then later the appellate court both agreed with us and found the law unconstitutional. But the state persisted and petitioned the entire Sixth Circuit Court of Appeals to rehear the case. It agreed, and on April 14th, reversed the case. So the injunction was dissolved and the law came into effect today. We have worked with our clients who are abortion clinics and physicians to plan how to comply with its provisions while we consider next steps. Obviously, I can't say what these litigation steps would be, but possibilities would obviously include seeking review in the Supreme Court, continuing to litigate the case in the district court, or a multitude of other steps. Next case I'll talk about is preterm Cleveland versus Yost. The so-called Heartbeat Protection Act would effectively criminalize most abortions in our state because cardiac activity can be detected in an embryo as early as 6 weeks after the woman's last menstrual period. This is when her period is about 2 weeks late. Most women are not even aware they may be pregnant at that point, but it would be too late to seek an abortion. We sued before the law could take effect and quickly won a preliminary injunction. That was in July of 2019, and the law remains blocked. After winning, we filed a motion to make our preliminary injunction permanent, and we're still waiting for a decision on that. The judge has explained that he is waiting to rule until 2 other abortion cases are resolved in the Sixth Circuit Court of Appeals. So we're in a holding pattern there. The next case I'd like to discuss, the next restriction is the method ban. This case is Planned Parenthood of Southwest Ohio versus Yost. This law that was passed at the end of 2018 bans D&Es, which is dilation and evacuation. This is the safest and most common second semester trimesters abortion method. The law prohibits what it labels dismemberment abortions, which is not a medical term, but it refers to D&E abortions of a, quote, living unborn child. The state construes the statute to permit a D&E abortion only if the physician first causes fetal demise, which is death by injection or umbilical transection, so that it's no longer a, quote, living unborn child. But to do this, to take these steps, is hazardous to the patient, and there's no safe second semester abortion alternative. So we challenged the law right away, asked for a preliminary injunction, and substantially won what we asked for. The law was enjoined in most circumstances. Essentially, when a physician determines that a demise procedure is contraindicated for a patient, which it is in most cases. With the preliminary injunction in place, the case was set to move ahead with discovery last summer to move towards a permanent resolution. But then the Sixth Circuit, which again is the appellate district that has jurisdiction over Ohio, held a similar ban in Kentucky to also be unconstitutional. And then the Kentucky Attorney General asked the US Supreme Court to take up that case. The High Court recently decided that it will hear that case, but it's limiting the question there as to whether the state attorney general should be permitted to intervene after the Court of Appeals invalidated the statute. So we're in a holding pattern in this case too. Next type of restriction I'd like to talk about are written transfer agreements, and the case is Planned Parenthood of Ohio versus Hodges. Ohio has a written transfer agreement, WTA requirement, that an abortion clinic needs to have a contract with a nearby private hospital to accept emergency transfers. This requirement creates a difficult, sometimes impossible hurdle for abortion clinics. And hospitals have to accept emergency transfers in any case, absent any contract. So this requirement is unnecessary. We sued on behalf of 2 Ohio abortion clinics, challenging the requirement. We won a preliminary injunction, so the requirement is on hold, and these clinics are operational. But like the 2 other cases I just discussed, this case is also on hold while other WTA cases are being decided. The last type of reproductive case, the last one I'm going to talk to about today, illustrates another type of attack on reproductive rights. And this is the harassment of abortion clinics under Ohio laws wielded by anti-abortion groups. This case is Right to Life Action Coalition of Ohio versus Capital Care of Toledo, LLC. Several anti-abortion organizations retained the Thomas More Society, which is a conservative public interest law firm dedicated to anti-abortion and anti-LGBT causes, to file a meritless lawsuit against the only abortion provider still standing in the northwest quadrant of our state. The plaintiffs claim that Capital Care and its owner are engaging in the practice of medicine without a license because neither the organization nor its owner holds a medical license. But obviously, the physicians who work for the LLC are the ones who are practicing medicine, and they hold licenses. So this is completely consistent with Ohio law about medical LLCs and how they're supposed to operate. So not only is the case itself harassment, but the plaintiffs filed this lawsuit in a court, Wood County, where there was no legitimate basis to bring this case. Why do they do this? The judge himself pointed out on the record that he was friendly with the plaintiffs and their main witness. We filed a motion to move the case to Lucas County, where the location where venue is proper, where everybody's located, every activity takes place. And that motion, of course, was granted. I can share with you our next step in this case. We are going to file a motion to recoup our fees incurred in transferring the venue. At this point, I'd like to turn to our very amazing staff attorney, Elizabeth Bonham, who's going to talk about our transgender birth certificate case. In view of all the retrograde anti-trans legislation that's being proposed and acted in Ohio and all over the country, this case is one bright light, which Elizabeth will shine on for you.
Thanks, Britta. Hey, everybody. Thanks for having me and being here. If you don't mind, I'm going to start a 5-minute timer so I don't run away with our time here. So like Freda said, I'm going to be discussing a trans rights case. Right now it's captioned Ray versus McLeod. I'll just run through a little bit of case history, its current status, and the significance I think it has. Now, this case is about getting transgender people born in Ohio access to accurate identity documents, specifically birth certificates with an accurate gender identity indication. And accurate documents has always been a barrier for the transgender community, of course, and it's been litigated. As you can imagine, if you transition and, for example, your driver's license still bears your dead name or the wrong gender indication, it exposes you to being outed, it exposes you to danger, all the way down to just mere delays or logistical hiccups trying to get somewhere that anybody would need to go. So it's really been years since we and some of our partners in the state, Equality Ohio, Trans Ohio, and others initially started researching what could be the barriers here in Ohio in this regard for trans people. And we discovered that at the time, even 5 years ago, Ohio was one of just a handful of states that still maintained a functional ban on transgender people obtaining gender correct birth certificates. So, we tried advocacy to resolve this, and a little over 3 years ago, we had to sue. We sued on behalf of 4 of our clients, still with us, very brave transgender people born in Ohio, being denied these identity documents. And the defendants in the case are officers of Ohio Department of Health's Office of Vital Statistics, which is the agency that issues birth certificates. In the case, we allege 3 causes of action. 1, that the ban violated the Equal Protection Clause because transgender people were being treated differently than everybody else. Cisgender people like me can get accurate birth certificates without even thinking about it. If I applied to go to college or if I needed a new passport, I wouldn't have a problem. Second cause of action, that the ban violated people's due process right to privacy. As I mentioned, when you show an inaccurate identity document, it can out you, exposes the person to real danger. And as we had to litigate, our 4 clients had experienced this. And finally, we asserted that the ban violated the First Amendment prohibition on compelled speech. By refusing to provide an accurate identity document, the government was forcing people, when they had to show this document, to endorse the state's position, really that they didn't exist, that they didn't belong. So after a couple of years of litigation, we filed cross motions for summary judgment. On December 16, 2020, we won an order. The Southern District of Ohio ruled that the health department could not constitutionally maintain its ban on providing transgender people born in Ohio gender correct birth certificates. Any government interest, the court ruled, in maintaining this ban paled in comparison to the grave privacy interests that our clients and others have at stake in maintaining correct identity documents. So the court issued this injunction saying no more ban, but it didn't enjoin the health department to do something in particular, right? So since then, as I'm sure many folks in the audience know, we've been ready for the Ohio Health Department to promulgate a new procedure for people to get these birth certificates so that the injunction means something for lived justice for people. Most recently, I can share there has been a filing indicating that the health department is working on getting this in place for June 1st. So we're really excited about this. We are, and I'm sorry that I can't share more detail now, but we are definitely going to be working with our partners in the state. I mentioned Trans Ohio and Equality Ohio, but just many others, grassroots organizations who have always been getting this kind of justice for people, working towards this kind of justice for people. We're going to be collaborating with them to make sure that this thing is accessible for people on the ground, whatever it does look like. These bans, I do also want to say, they're being knocked down all around the nation. As of now, since we started the case, there were a handful of these bans. Tennessee is the only ban left standing, and there is a lawsuit pending in Tennessee as well. I know, as Freda said, there's just a massive assault on trans rights right now. And I feel deeply that the right thing will prevail, and we're going to continue to fight this stuff. So my timer didn't go off. I did okay, I guess. Let me introduce my colleague, my comrade in arms here, our senior staff attorney, David Carey, who's going to talk about some of our prison litigation.
And I'm going to jump in real quickly as David is preparing. Just to remind, if you have questions, drop them in the question and answer or in the chat, and we will address them when we get closer to the end.
Okay, so of all the people who were impacted in the last year by the COVID-19 pandemic, one of the most vulnerable groups, and therefore one of the hardest hit, was the incarcerated population. But frankly, their well-being and even in their lives appeared to be among our government's lowest priorities. So over the course of the past year, we had a series of lawsuits with the goal of getting people out of prison or out of civil detention, where the conditions were leaving them incredibly vulnerable to the coronavirus. But beyond that, I'd like to talk about a slightly different type of prison case that we just brought recently. And that case is called Woodson versus ODRC. So as most of us will remember, in March of last year, as the pandemic was escalating and everything was locked down, Congress passed the CARES Act, which provided emergency relief payments of $1,200 to eligible people across the country, including prisoners. The question, though, quickly came up whether those payments could be seized or garnished by creditors, or whether the payments could just go straight to the people who needed them. And for the most part, Congress left this up to the states to decide. And Attorney General Yost made Ohio's view on that very, very clear. Congress intended these payments to be emergency relief. People all over Ohio were losing their jobs, were having their work hours cut, and badly needed this relief money. And the point of the CARES Act was to help people get through that economic stress that came about as a result of the pandemic. So the Attorney General announced his interpretation of the law. He said that everyone in Ohio, regardless of the type of person, is entitled to get this money free and clear of any garnishment. And that includes garnishment for debts to the government, things like court fees, which for anyone who's interacted with the justice system, those fees can snowball quickly and can quickly become difficult to pay down. So many, if not most people who are incarcerated have debts because of court fees. But what happened next is, as the stimulus checks actually started coming in, Ohio prisons decided to seize any checks that were directed to prisoners. And ODRC, which is the prison agency, went against the Attorney General's determination and decided to apply a much more limited exception to garnishment. So only allowed a small portion of those $1,200 payments to be free from garnishment, and the rest could be seized by the government. And they were mostly for court fines and for fees. So we believe there's absolutely no reason why people who are incarcerated should be treated differently in this context, because in fact, many of them desperately need this money. People who don't have exposure to the prison system may not understand this, but the truth is people who are incarcerated often struggle financially more than almost anyone. Even in normal times, their food rations are often insufficient, so they have to buy food at the prison commissary just to have enough to eat. If they need any medicine or any vitamins, they have to buy it. If they have to buy any hygiene items, if they want toothpaste or shampoo, they have to buy it. And prison commissaries are notorious for having inflated prices. And incarcerated people often work full time, but are paid typically something around $15 to $20 a month is common for their full-time payment. And on that pay, they have to purchase all the things that they need from the commissary. So add on to that the difficulties of COVID. So even setting aside the fact the disease itself was tearing through Ohio prisons, a lot of people in prisons depend on financial support from their families. And those families themselves had lost jobs, had lost hours. And a lot of the people who were incarcerated may need medical care, so they had to buy their supplies for that. And with prisons locked down, the only way they could even talk to their families was to pay for phone time. So the bottom line is they needed this federal relief money as much as, if not more than anyone. But they were the only category of people who Ohio's government saw fit to try and seize those payments from in order to pay these court fees. So we filed a lawsuit against the prison system about a month ago. Our clients had hundreds of dollars taken out of their relief payments, and we're arguing that this policy of seizing their funds violates their constitutional right to equal protection, and that they should be entitled to receive the full relief payments just like everyone else. So that case is in the early stages, but we're hopeful that we'll see a good result. So beyond that, I was hoping to discuss another case involving mass incarceration. It's not quite right for discussion yet in specifics, but I can say that we're hoping to continue some work that we've done in the past regarding the Ohio Parole Board. And I think of this as sort of the back end of our state's mass incarceration problem. Refusing to provide parole is, of course, not what puts people in prison, but it is what keeps them there, often for decades beyond their minimum sentence. So when people in Ohio are eligible for parole, they come up in front of the Ohio Parole Board, this 10-person body that really operates in secrecy. The person who's eligible for parole has an initial hearing at the prison. They don't get to have a lawyer present. It's just them sitting there with the parole board. And they just sit there and answer whatever questions they're asked. And in practice, this is often less focused on what they've done in the past years or decades to improve themselves, to build job skills and so on, but more focuses on revisiting the underlying offense from years ago, walking through every single excruciating detail. But if they pass that stage, they then proceed to a second hearing, And at that hearing, often prosecutors or victims' representatives often show up to argue against their release. Again, usually based not on what has happened recently or who the person is today, but based on what happened years or even decades before, which is already something that's built into their sentence to begin with. So after that, the parole board issues a written decision, and if the person is denied, they might get one or two very vague sentences explaining why. It can be something as vague as your underlying offense was too serious, or we believe it would not serve the interests of justice to release you. So they often walk away from that process without any real idea of what they can do to earn parole. So there are a lot of problems with that system, obviously. One of which is that it operates in a black box. In some cases, the person doesn't even get to see all the information that the parole board is looking at, which would allow them to respond to any errors or falsehoods in that information. Another problem is that the board itself has almost completely unlimited discretion. Their decisions can be inconsistent or arbitrary. And a couple of years ago, we filed a lawsuit against the parole board where we had gathered evidence that the board had this unwritten practice in homicide cases of denying everyone their first time up, regardless of their actual merits. That case ultimately settled and our client was released. And it also helped put some pressure on the board to make some policy changes and personnel changes to move them in the right direction. So ultimately, the fix for the system needs to be legislative, to change how the board operates and how it makes its decisions. But until then, we're hoping to continue to do what we can with litigation to ensure that people who are eligible for parole get a fair hearing. So all I can say for now is just watch this space. We hope to announce something soon. So with that, I will throw it back to our fearless leader, Freda, to talk about voting rights.
Thanks, David. So one of our core areas of litigation is always voting rights. Voting is precious, of course, because it's protective of all of our other rights. Currently, we're working to prepare for two areas of very possible litigation. And again, while future litigation plans would be confidential, it's going to surprise no one that we're looking at these things because this is so obviously fundamental to what we do. And one is redistricting. We're very concerned about gerrymandering. We've sued over it before. This is the partisan or racial manipulation of the map drawing process. And we're going to be engaged in and monitoring the new map drawing process very carefully. As you probably know, federal census data is delayed, seriously delayed, which has thrown off Ohio's constitutional timelines for redistricting. So what the schedules will actually be has not been determined yet. We have concern that any schedules allow sufficient time for public input and oversight. And we also have concerns about the quality of the data that the state might try to use as a shortcut to expedite drawing the maps. We know that one format of data, so-called legacy data, will be coming out in mid-August, and completely formatted census data will come out at the end of September. These are the only accurate and reliable sources of data. And we're completely, we're beyond skeptical. We know that other sources will not be accurate or reliable. When the process starts, we're prepared to conduct highly sophisticated analysis of any proposed or enacted map to see how it's going to perform in practice. If it comes to pass that any map enacted by our state confers an unfair partisan advantage, if it violates federal law by infringing on the rights of Black voters, or if it violates the one person, one vote principle, we're going to be able to discern it, and we will almost definitely challenge that map in court. Another set of issues relating to voting rights are voting restrictions. Typically, historically, when there's been an uptick in voting in our country, such as in the last election, when an unprecedented number of voters turned out to vote absentee, a wave of voter suppressive laws follows. Now, of course, is no exception. In response to the big lie that massive fraud ran rampant in the last election, states across the country started enacting new provisions to place limits on how people can access the ballot. The themes virtually everywhere have been restrictions on drop boxes, stricter voter ID laws, limitations on early voting, limits on when ballots can be sent or counted, and so forth. And in Ohio today, a bill, HB 294, was introduced by Representatives Seitz and Ray. It just dropped this afternoon, so pronouncements about it would be premature, but it clearly has concerning provisions. It includes cuts to early voting hours, stiffer voter ID requirements, limitations on the use of drop boxes, and other provisions. Many of these will have a disproportionate impact on Black and Brown voters, on low-income Ohioans, people with disabilities, active duty military members, and seniors. Challenges to restriction like these are our bread and butter. This is what we do. In the past few years, we've brought lawsuits challenging limitations on early voting opportunities, scheduling of elections, limitations on drop boxes, issues surrounding initiative petition signatures, purges of eligible voters, and repressive policies that toss out ballots for subjective reasons. And it's become pretty clear that we're going to be embarking on more of these in the near future. At this point, I would like to reintroduce Elizabeth, and she is going to be talking to you about another extremely important area of our docket, constitutional policing cases.
Thanks, Rhoda. So that's right. I'm going to talk today just about two of our constitutional policing cases. I should say unconstitutional policing. That's where we come in. That both happen to be our clients we represent against Columbus Police or members of the Columbus Police Department. The first case I'd like to discuss is currently captioned Hana Abdur Rahim versus the Columbus Police Department. And in this case, we brought suit all the way back when people were out protesting in Columbus against then President Trump's initial Muslim ban. At that protest, I think it was January of 2017, peaceful protest, members of the Columbus Police Department pepper sprayed the crowd to get them out of the street. Our complaint alleged certain other members of the police department after that initial spray then went after individuals, including our clients, pepper spraying them again at close range. We brought First and Fourth Amendment claims alleging that the use of force with that pepper spray was unreasonable under the Constitution, and that it was retaliatory under the First Amendment for the exercise of the First Amendment protest right. And this, just like Freda said, just like voting rights, this kind of thing is our bread and butter. You know, this is part of what the ACLU exists for, to protect that right to protest. In this case, and at the risk of speaking any legalese, I want to talk about two types of claims that we brought. So we brought use of force and First Amendment claims. We brought them against the city, and that's called often a Monell claim, and we brought them against individual officers. So often when you are bringing suit for damages against an individual police officer or state actor that you're saying has attacked you, what you need to do is you need to defeat a doctrine called qualified immunity. And qualified immunity, it's a federal court made doctrine. It's, I think there's an enlarged understanding among the public now of what that means and the kind of barrier to civil rights recovery it is. What it really says is, even if somebody violated your rights, they can't be held accountable for that unless those rights were clearly established under the federal law. It's a very difficult and sometimes an ultimate bar for a plaintiff to have to pass, and that's against individual officers. Then another type of claim that we brought, it's referred to as a Monell claim. And this is a claim where you can recover against a city or an entity like a police department. But in order to recover that way, you need to show and have sufficient evidence that there's some kind of pattern or practice. In other words, that this wasn't just a one-off occurrence. So in our case, on behalf of Hana and others, we brought both of these types of claims, both against the city of Columbus and the department and individual officers. We went up and down from the Sixth Circuit on qualified immunity. Ultimately, the Sixth Circuit dismissed our case against an individual officer on qualified immunity grounds. The district court found that we didn't sufficiently prove up a Monell claim, and we wound up back in the district court on just a single claim, assault and battery, that this person had, come after our client with pepper spray in the face and just, plain old assault and battered her. No qualified immunity applies there. And that's where our case stayed, in that posture in the district court. And I'll address that again in a second. Another case that we brought that I wanted to touch on a little bit more recently, also against members of the Columbus Police. This was just a case brought against the individual officers on behalf of a man, Nick Pettit, who in our complaint we allege was filming from his own front porch some members of the police while they were involved in something else on a public street. The officers, he says, came up, grabbed his phone, arrested him. And again, we alleged that this violated the Fourth Amendment because of the use of force in the seizure, and the First Amendment because, of course, it's protected conduct to talk to the police, it's protected conduct to film the police, and to do these peaceful things to hold the police accountable in your community. These are just a couple of these types of cases that we have on our docket pending right now. I can share that in both of these cases, pretty recently, the parties have filed notices that they are in a settlement posture. I unfortunately can't share the details, but I will love to do that when that becomes public. And, just again, really proud of our clients, really proud of the people and the things that our clients represent in terms of trying to keep holding police accountable and keep exercising their rights. So with that, I think I'll kick it back over to David to talk about some other First Amendment cases on our docket, I think.
Yeah. So as Elizabeth said, defense of free speech is our bread and butter. Historically, the ACLU name is synonymous with it. And the thing is, there's never a shortage of it, because apparently trying to censor people never seems to get old. The government puts a lot of creative energy from the federal level on down to local police into finding ways to silence people who they frankly just find annoying. And one of the things you quickly notice in free speech cases is that popular people who are wielding a lot of political power in that moment usually don't need the First Amendment to protect them from the government. They're protected by the fact that they are in power. It's usually the unpopular speakers, the vulnerable people who are targeted first, because the government thinks nobody cares about them. And then if the First Amendment protections get watered down in cases like that, then it's ultimately people with the least political power who suffer in the long term. So it's clients in First Amendment cases are often not in the good graces of the government or even the general public. And Elizabeth talked about a couple of examples of what that kind of case might look like. And we've seen others like that. We recently wrote a brief to the Sixth Circuit in a case called Wood versus Eubanks in support of a man who was arrested for making some less than perfectly friendly comments to the police in Clark County. He was in a public space at a fairground. He never threatened anyone. There was no hint of violence, but they arrested him anyway for disorderly conduct on the theory that when he insulted the police, they said his words were so offensive that they would tend to provoke a violent reaction from the police themselves, which, if true, would mean that his words were not protected by the First Amendment under the fighting words doctrine. So we argued, first, it's a very high bar for something to be so incredibly outrageous that it would provoke immediate violence. Saying F the police doesn't quite cut it. So that's point one. And point two, the bar for that has to be even higher with police. They're not just people on the street, they are sworn officers of the law. And whether or not they live up to this, they are trained and expected not to lash out violently just because someone says something rude to them. So we're hoping that that case will set another good precedent for free speech. But I'd like to also talk about one more. And this is a case where we spoke out on behalf of, and I regret to inform you I'm not making this up, robocallers. You might have thought that I was exaggerating with the unpopular speaker thing, but this is actually a really good example of the dynamic that I'm talking about. This case is called Lindenbaum versus Realgy. There's a federal law called the TCPA going back to the 1990s that makes most robocalling illegal. And in 2015, Congress added in an exception to that for government debt collectors. So after that, no one could make robocalls unless they were calling to collect on government debt. And this is a pretty clear First Amendment violation. The government doesn't get to censor speech based on what's being said, because doing that creates sort of a selective system where there's a favored class of speech and a disfavored class of speech, and the government doesn't get to pick and choose which ideas or which speakers are worth promoting. And the Supreme Court said so in 2020. The case was called Barr versus AAPC. And in that case, they said that going forward, that government exception that I mentioned was invalid. So we're back to where no one can make robocalls. But what they didn't do is say exactly what happens with robocalls placed in the interim period between 2015 and 2020, when the government debt exception hadn't been struck down yet. So it seems pretty clear during that window that the government debt collectors can't be punished for making calls. It wouldn't be fair to punish them because they were just relying on what the law said. So what about everybody else? And that's what this case, the Lindenbaum case, is about. This involves a company that allegedly made robocalls during that time period, and the case was brought against them shortly before the Supreme Court struck down that exception. And their case is up on appeal to the Sixth Circuit. So we wrote an amicus brief saying that even if they did make robocalls, they actually can't be punished for that. Because if they could be punished, but the government debt collectors could not be, then the government is essentially preserving that selective system that I was talking about, where some speech is favored and some speech is disfavored. But our brief also explained the ramifications beyond just robocallers. So for example, there was a recent case in Michigan where a teenage girl was protesting at a traffic light for Black Lives Matter. And she walked out among the stopped cars at the red light with a sign, and she was arrested for obstructing traffic. And the law that she was arrested under said that you can't obstruct traffic, but it created an exception if you were fundraising for a charity. A similar situation where the government is trying to pick and choose what speech is good or bad. And that law was struck down as unconstitutional, but her state case was still going on after that, because at the time that she did it, it hadn't yet been struck down. So what we pointed out in the Lindenbaum case is that if the Sixth Circuit goes the wrong way in this robocalling case, her case is pretty similar. And what they'd essentially be saying is that she can be punished, even though the law that she's being punished under is clearly unconstitutional, because it favors some speech more than hers. So there hasn't been a decision yet in the robocalling case, but we're hopeful that our involvement will help the Sixth Circuit see past the identity of the robocallers, the unpopular speakers, to the people like this protester who will ultimately be at the receiving end of any bad First Amendment rulings that come down. So with that, I will throw it back to Raphael, our faithful moderator, to take us home.
Good deal, good deal. That's a lot of information in a very short period of time, but wow, it's almost like you guys don't sleep. There's a lot of litigation, and that actually probably goes to one of the first questions that we have is, there are a lot of things going on in the state of Ohio right now. How on earth do you choose a case? How do you pick a case? What makes an ACLU case versus something that would go to an average everyday lawyer?
That's a great question, and it deserves an answer. We obviously can't take every case that we're interested in. There is so much out there, and there fortunately are other wonderful organizations and talented lawyers out there that can conduct other cases. What makes a case for us is obviously if it implicates the Constitution, if specifically the Bill of Rights, the relationship between people in our country and the government, and if it is of high impact. We certainly there's constitutional cases that arrive that affect individuals, really ones that affect them in a big way that are very important. But it's our mission to take cases that affect a lot of people, or that promote or a constitutional right in a way that will impact a very significant number of people. We also think about when we take a case, could we, by taking this case, even though it's very important, run the risk of getting a bad decision? Is this a smart case for us to be taking right now? Are we sticking our necks out too far and risking harming the state of the law? Because as you know, there's the wind, the pendulum shifts as to what judges are on what court, attitudes, timing can be everything. So sometimes, we would like to take a case, but we think it would be unwise, that the risk would be too great. Other times we make choices because we could take a case, but it happens to be brought under a provision of the law that could generate, easily generate a lot of money for the successful lawyer bringing the case. Well, that could be a case where the private bar would be very willing. Excellent lawyers in the private bar could take that case so that we may not need to. So that's another consideration. Maybe David or Elizabeth want to amplify that answer.
I think you covered it. I think the only thing I would add is essentially just a repackaging of what you said, which is that, there are many injustices that go on in our criminal justice system, in our government generally, and we only have two hands. We have to be very careful and very selective about what we choose. So many cases come to our attention that we wish we had the bandwidth to take on, and we just can't. So we have to be very careful and strategic about how we choose our cases.
Thank you. Thank you for that. Here's another question, and it's probably for both Freda and Elizabeth, but in different kind of realms. Freda, you were talking about election law and voting rights, and some of the onerous bills, or there was a onerous bill that was just recently passed, but there's talk at the federal level of kind of doing something that would the John Lewis Voting Rights Act. And Elizabeth, you were talking about some of the policing issues that are going on, and there's also talk at the federal level of the George Floyd Police Reform Act. What happens if Ohio passes these laws before the federal government passes them? What then, which law would be take place, or how would that work out?
So a valid federal law would supersede Ohio law, but there are real questions about states' rights when it comes to voting. States do have a lot of authority that the federal government needs to respect in terms of the conduct of elections within that state. Specifically, the question of who can vote is generally regarded to be an issue of state within the state purview and not the federal purview. So there is a interaction between federal and state laws that impacts the right to vote and the conduct of voting in Ohio. Now, I think the likelihood of a voting restriction bill being passed in Ohio seems much more imminent than some remedial bill being passed in Congress. So I don't think we can hold out our hopes that some kind of corrective bill getting passed later in Congress would solve any problems we have here, even if it could supersede or control some of the onerous aspects of the Ohio bill. We really need to focus and take care of what is going on in our state.
And I'll just add with respect to policing, just like Freda said, I mean, there's a federal supremacy issue. So I think I'm not too familiar that the George Floyd Act that's been introduced in the federal legislature purports to control, state and local government as well as federal. And, if that law is supreme, that law is supreme. Great, it controls us. For the time being, we have to grapple with what's going on in Ohio, right? I'll also say that with respect to qualified immunity that I mentioned before, I mean, that is a huge barrier to, plaintiff recovery in a civil context and, getting police accountability that way. That's a federal court created doctrine. It can be abolished by the federal Congress. And, I understand that there have been efforts to do that as well. I'm not sure of the status of similar parallel bills on the state level in Ohio, though I have seen that in at least one other state as well. So I think these are two tracks to justice.
Yeah, the only thing I would add is just that with the state level, Ohio there is a bill under consideration in the very early stages to provide a way, sort of an end around qualified immunity by creating a new way for people to file lawsuits for policing violations. But that's a different mechanism. If qualified immunity itself is going to go away, as Elizabeth said, that has to be at the federal level.
Excellent. Thank you for that. Here's a reproductive rights question. There seems to be a lot of different laws in different states and different states of kind of litigation and lawsuits. Why does it seem like sometimes that like one state will wait for an outcome in another state or something along those lines, especially when it comes to something like reproductive rights, where, you know, Roe v. Wade is the law, you know, across the country?
In general, the situation in the cases that I mentioned today is that we have district courts, which are the trial level court in the federal system, who are about to make a decision, knowing that the Sixth Circuit Court of Appeals, which articulates the law interprets the law for the entire set of states to which Ohio belongs, if they're about to render a decision that would control the district court should, you know, they're just exercising the self-restraint to wait and see, because it wouldn't be economical. It wouldn't make sense for them to render a decision that they're about to receive guidance on, or that they're about to receive information that there's a controlling authority on. So they're waiting. And meanwhile, we have solid preliminary injunctions in place so that clinics are operating, women are receiving the medical care, reproductive care that they need, so that the status quo can be preserved in a favorable way while we're waiting for those outcomes.
It wouldn't be a Zoom if I didn't start talking while I was muted. Now I was going to say, David or Elizabeth, did you want to add anything on the reproductive rights question? Okay. David, here's a question for you on the DRC case that you mentioned. The question is, did you mention that there was a court order that said that they were not supposed to take the individual's money, but they did it anyway? How can a state agency get away with doing that?
Sure. So there wasn't a court order, and I'm sorry if I didn't explain this very clearly, because it is a complicated history. The Attorney General Yost, announced that this would be the position of the government. He said that in Ohio, everyone is supposed to get this money free and clear without it being garnished, including for court fees. And he announced that that was the policy of the state as far as he was concerned. What happened next was the prison agency, DRC, just ignored that, essentially. They just started seizing these funds, the emergency relief funds that were coming in from the federal government. So that's what the equal protection problem is that I was talking about. Some people are being treated differently than others. And in this case, it's only people who are incarcerated who are having this money taken away to pay down court fees, whereas anyone else, regardless of their circumstances, will get those CARES Act funds, or have gotten those CARES Act funds, free of any threat of garnishment. So the bottom line is they just simply ignored what the Attorney General said, and we think that's unconstitutional.
And here's a follow-up for me on that. What happens, so the money that was taken, if the lawsuit is successful, does it go back to the inmates, or, you know, or do you know, or would that be a part of the litigation? The
exact situation would be up to the court, but we believe, yes, it should go back to the people who it was confiscated from.
Okay. Here's another reproductive rights question. Freda, you've mentioned that there were some, what I think the word you used were frivolous claims about, you know, how the doctors, whether the people who had the company were actually the medical license. Is there anything that can be done to stop those type of lawsuits from being filed when you have something as clear as you have an owner of a company, they're not the doctor and they're not purporting to be the doctor, but yet they pass a law that says, you know, even the owners of the company have to have a medical license?
In extreme cases, if a case is brought in bad faith, extremely frivolous case, where the lawyer knows they shouldn't be bringing the case and it's baseless, brought for purposes of harassment, it's possible for the defendant later, after the case is resolved, to turn around and ask that their attorney's fees be paid by the other side. That would be the remedy for that kind of thing. We're not at that point in this case, but that's the general legal principle that exists to handle that type of situation.
Gotcha. We are rapidly coming up to the end of our hour. We have about 4 minutes left. In that time, maybe we'll do a round robin here. Probably more opinion than hard facts, but we know that there's been a lot of changes between administrations, a lot of different judges. How is that impact the decisions that you make, or whether you're in federal court versus state court, or a particular federal court versus another? How does all of the change in both at the federal level and at the state level, when it comes to new judges and new positions, does that impact litigation from your perspective?
In general, there are rules that determine where it's appropriate to file a case. You can only file in federal court if there's federal jurisdiction for it. You can only file in a court where there is appropriate jurisdiction. In some cases, there's more. A court can hear more than one type of case. But then, if you file there, if that's the case, often the defendant can do what's called remove the case to federal court if you have filed in state court. And
I think we lost Freda. So I think she was.
I'll pick up where she left off. As she said, there are. Oh, there she is.
There you are, Freda. Freda, we lost you for a moment. You were frozen.
Oh. I'm sorry. Maybe is it better if I turn off my video?
Sure. Go.
To
Yeah.
address
go ahead.
that, maybe it's better for people to hear a speaker or Elizabeth.
Exactly. There we go. Well, listen, we will do this. We will end on I hope a high note, and I'm going to take moderator's privilege here and toss it to Elizabeth Bonham and ask, what is the coolest thing about being an ACLU lawyer?
You know what? I've been thinking about this a lot recently. I just have to say, I really believe in the work we do. I believe in our clients, and I believe in our team. And so the coolest thing in the world is to get up in a court of law and say that you're with the American Civil Liberties Union.
And that's open for everyone in the last 30 seconds. David, Freda.
Sure, it makes me practically want to cry every time I can say I'm here from the ACLU of Ohio. It's such an honor to be a part of this legacy. The other really cool thing is to get to work with Elizabeth and David, who are brilliant.
The other thing I would add to that is that one of the hard things about practicing law sometimes is wondering whether your client is right, whether what you're arguing for is right. We don't really have that problem here. We serve the interests of justice in a way that is incredibly satisfying and an incredible honor to do. So I think we're all very pleased to be here and lucky to be here.
Well, David, I don't think we could end on a higher note. I will echo Dan in the chat, who says, thank you all for your hard work and for the hard work that you do for all people. And I think that's definitely the best way to wrap this. We do sincerely thank you all for your time. We know you're busy. And right now we're going to say, get back out there and fight for those civil liberties and civil rights. We really appreciate all that you do. And we thank everyone who joined us on this event today. We really appreciate it. We thank you guys, and we will see you at the next one. But as soon as we get that one in the hopper.